welcome to Circle Up Strategic Mediation Tips for Complex Litigation. I'm Ala Policastro, CLE Advisor for Beverly Hills Bar Association, and today I'm delighted to introduce our speaker, Jill Manning. Jill Manning is the founder of the Manning Law Firm. She is a mediator, trial attorney, and skilled litigator. Ms. Manning has represented clients in class action and complex litigation matters in state and federal court in a wide variety of fields, including antitrust and competition, consumer protection, privacy, healthcare, mass torts, sports, and securities law. In 2025, Ms. Manning joined JAMS as a mediator, arbitrator, special master, neutral evaluator, and discovery referee. She is also a mediator for numerous court-based ADR programs in courts across California. We can't wait to hear what she has to share with us today, so let's get started.
Great. Thank you so much for that kind introduction. I really appreciate it. And I am delighted to be here today. Thank you so much to the Beverly Hills Bar Association for inviting me to speak on this topic. And thank you to everyone in the audience for joining me today for this presentation on Unlocking Success, 6 Tips for Complex Case Mediation. Now, like all the litigators in the room today, most of my cases settled prior to trial, and most settled using a private mediator. Some mediators were helpful, others were not. And I often found myself wishing for a mediator who did the hard work to truly understand the case, who listened carefully, not just to speak, but to understand. A mediator who treated everyone with respect, even in the most high-stakes adversarial settings. A mediator who was skilled at productive dialogue and facilitating productive dialogue. Someone who was thoughtful about creating creative solutions. And someone who stayed committed to helping the parties reach agreement, even in the most difficult cases. So I became that mediator. And now I approach each matter with the same intensity, preparation, and strategic thinking that I brought to my cases as an advocate, but with a neutral's perspective. This dual experience as both advocate and neutral has taught me what really works in mediation and what doesn't. So today I'm sharing those insights with you so you can get the most out of every mediation. The circle method we will explore today comes directly from these real-world experiences on both sides of the table. So today's goal is to learn tips for preparing for mediation strategically and learning how to set yourself up for a successful outcome. Statistics show that between 95 to 98% of all civil cases settle before trial. And that certainly resonates with my experience. During my 30-year career as a litigator, I had only 2 cases go to trial. That means if you're in litigation, there's only a 2 to 5% chance you'll actually take your case all the way to trial. Given those odds, it makes a lot of sense to take the time and approach mediation strategically. So court-ordered mediation presents a powerful strategic opportunity. Imagine this scenario. You're representing a client in a complex case where the judge orders the parties to mediation. It may not feel like welcome news, but it prevents a tremendous opportunity. First, mediation allows your client to explore resolution without signaling any weakness. Your client did not initiate the process, the judge did. Second, by approaching the session strategically, you will leave in a stronger position than when you started. Whether or not settlement is reached, you will gain valuable insights into the opposing party's strategy, a fresh perspective from a neutral, and a clearer path forward. Most importantly, mediation gives you the opportunity to shape the outcome, rather than leaving it in the hands of a judge or a jury. So CIRCLE is a helpful acronym where each letter represents one of the 6 topics we are going to discuss today. So the first topic we're going to discuss is choosing your mediator wisely using the C in CIRCLE. Choosing your mediator wisely, identifying strengths and weaknesses, developing a range of settlement options, staying calm and curious, learning through joint sessions, and evaluating settlement options carefully. So let's dive right in with choosing your mediator wisely. Selecting the mediator is one of the most important decisions you will make in the entire process. A successful mediation often hinges on the mediator's neutrality, experience, subject matter, and style. Take the time to evaluate each candidate's background and approach in light of the specific dynamics of your case, your client's priorities, and your strategic goals. A well-matched mediator can build trust, manage conflict effectively, and significantly increase the chances of reaching a meaningful resolution of your case. Don't treat this as just checking a box. Invest the time to find the right fit because it will pay dividends throughout the process. So we're going to discuss 4 key factors in choosing your mediator wisely. The first one is neutrality, and this is non-negotiable. Neutrality means the mediator has no stake in the outcome, holds no predetermined opinions, and demonstrates no favoritism toward either party. Carefully vet proposed mediators by asking targeted questions. Have you ever worked with opposing counsel? Have you had any professional relationships with the parties or attorneys? What's your initial reaction to this type of case? Do you have any industry connection that might create conflicts? These questions help identify potential biases before they become problems. Even the appearance of bias can undermine the entire process. If one party suspects favoritism, they'll question every suggestion the mediator makes. A truly neutral mediator creates a safe space where both sides feel heard and respected, which is essential for productive negotiations. Remember, you want a mediator who can challenge both sides equally and maintain credibility with all parties throughout the process. So ensure that the mediator that you select is neutral. The next factor that you should consider in choosing your mediator is subject matter expertise. Consider whether you need a mediator with experience in the area of law or industry that is at issue in the case. Complex cases have nuanced legal and practical issues. Let's talk about a few examples. In antitrust cases, a mediator needs an understanding of market dynamics and econometric analysis. Damages in antitrust cases turn on expert opinions, often using complex regression analysis. Having a mediator who can understand those damages theories is going to be quite helpful in your case. In intellectual property cases, a mediator requires technical knowledge. Employment matters benefit from a mediator with familiarity with workplace dynamics. So don't assume all mediators are equal. Specialized knowledge can make the difference between settlement and impasse. So consider whether having a mediator with subject matter expertise would be helpful in your case. The next factor that you should think about in selecting a mediator is whether they have experience in complex cases. High stakes or multi-party cases require mediators with proven experience managing complex disputes. Look for a track record with high stakes disputes and multi-party experience. In your pre-vetting process, ask, what's the most complex case you've ever mediated? You need someone who can manage multiple moving parts and navigate the legal, logistical, and interpersonal challenges these cases present. Complex cases often involve competing interests among multiple parties, substantial financial exposure, and intricate legal issues that require carefully sequencing of discussions. An experienced mediator knows how to structure the day, when to use joint sessions versus separate caucuses, and how to keep momentum going when negotiations get bogged down in details. They also understand the unique pressure that comes with high-stakes disputes and can help the parties maintain perspective when emotions run high. I'm going to pause here and see if we have any questions from the audience. I'm happy to take questions whenever they come up. So if I'm talking about a topic that raises a question with you, please feel free to put it into the chat, and I will do my best to remember to check carefully. Okay. All right. Now, the fourth factor that you want to think about in choosing your mediator is a style match. Different mediators employ varying styles. Facilitative mediators help parties communicate and find their own solutions. Evaluative mediators, on the other hand, provide assessments of case strengths and weaknesses. Transformative mediators focus on improving relationships. So choose a mediator whose approach aligns with your case dynamics and client needs. A well-matched mediator builds trust, manages conflict effectively, and significantly increases the chances of a meaningful resolution. So to sum up our first topic, which is choosing your mediator wisely, remember that the right mediator is your strategic partner. Invest time in selection because it's one of the most important decisions in the entire process. Okay, now we are moving on to I, identify strengths and weaknesses. All right, you've done the hard work and you've selected your mediator. Now you need to begin preparing your case thoughtfully for mediation. A clear understanding of both the strengths and weaknesses allow you to set realistic expectations and negotiate strategically. This balanced perspective helps you avoid overconfidence or unnecessary pessimism. So let's talk a little bit about leveraging your strengths effectively. Knowing your strongest points allows you to present them effectively in your written statements, and if you have a joint session, during opening statements, to influence the other party's risk assessment. Lead with your most compelling arguments and use supporting evidence strategically to build confidence. This approach helps shift the opposing party's perception of their litigation risk. When you articulate your strengths clearly and persuasively, you're not just advocating for your client. You are providing valuable information directly to the other side to help them make informed decisions about settlement. A well-presented strength can be the turning point that moves negotiation from posturing to serious discussion. However, resist the temptation to oversell or exaggerate. Credibility is your most important asset in mediation, and once it's lost, it is very difficult to regain. We also need to address our weaknesses proactively. Understanding your case's vulnerabilities helps you prepare responses rather than being caught off guard. Anticipate what opposing counsel will attack and how you will respond without being defensive. One mantra that I find very helpful is, if you can't fix it, feature it. Every case has weaknesses. Rather than hiding behind them and waiting for the other side to point them out, address it proactively. Acknowledge it openly. That helps you maintain credibility and helps reduce the sting of having your opposing counsel address it in the first instance. If you can't fix it, feature it. And also distinguish core issues that are non-negotiable from flexible areas where you can give ground strategically. Now let's talk about the strategic benefits of identifying the strengths and weaknesses of your case. This honest analysis enables strategic negotiation from a well-informed position. You can make targeted compromises while protecting essential interests, giving ground on less critical points to create momentum toward resolution. The key is conducting this analysis honestly, often with outside counsel who can provide objective perspectives. Self-deception about case strength is one of the most common barriers to successful outcomes. I've seen cases where parties had unrealistic views, plaintiffs thinking cases were too strong, or defendants being overconfident. When this happens, the mediator must work harder to provide reality testing and get the parties moving. Address this initially. Address your strengths and weaknesses of your case, because knowing the case's true strengths and weaknesses through honest self-assessment, this is your negotiation compass through the mediation process. Okay, looks like we have questions. Okay, I'm going to jump. The first question from Sally is, when do you use joint sessions? I use joint sessions in most of my mediations. Before the mediation session, I schedule a call with all counsel, a joint call, to talk about the process. And one of the issues that we discuss is whether it would be appropriate to have a joint session in the case. It is always my recommendation that we start with a joint session, and we'll talk about that a little bit more. But I find it's very helpful to use joint sessions. And unless there's a reason not to do it, and sometimes there is, I will have joint sessions. Okay, what is the balance between parties wanting the mediator to understand and experience in the law and industry related to the case, and being fully unbiased? I certainly think that they can go together. Having an understanding of the law and industry doesn't make the mediator biased, but it can provide them with really important information regarding the case. Okay, I hope those were helpful. And just another example regarding having industry or legal knowledge was the example that I gave regarding antitrust cases. And this applies to any highly technical area of law. Having that understanding from the mediator is going to help reality test the party's position. So when you get into an impasse situation, having a mediator who can push back and say, for example, look at the party's expert report and pressure test some of the conclusions can help the attorneys assess their risk in litigation. Okay, great questions. Thank you so much. Okay, we are now going to move on to the next slide. Okay, we're now moving on to R, range of settlement options. Develop multiple solutions that could meet both your client's needs and those of the opposing party. Consider creative and non-monetary terms based on your assessment of the case's strengths and weaknesses. Expand thinking beyond dollars. Payment plans and structured settlements can ease financial burden. Policy changes and procedural modifications can address systemic issues. Confidentiality and non-disparagement clauses protect reputations. Future business arrangements can create ongoing value. I've seen business disputes resolved with licensing agreements instead of damages, creating win-win outcomes that preserve relationships. Let's talk about client preparation. This is essential for a successful mediation. So before your mediation session, have honest discussions with your client about 3 key questions. The first, what do you want? Identify your client's ideal outcome and assess if it's realistic given the case circumstances. Second question, what is available? Establish minimum acceptable terms. your client's bottom line and walk away point. And make sure you include any non-negotiable elements. The third question, what happens if the case does not settle? We all know not every case is going to settle during mediation, but in order to develop a range of settlement options, it's important for your client to understand and think about what is going to happen if the case does not settle. Discuss the risks of continued litigation, timeline considerations, and cost implications. Address emotional versus practical considerations to set realistic expectations. These conversations are often difficult, but absolutely essential. Clients who have not thought through these questions beforehand can make poor decisions under the pressure of the moment. For example, if a client has not carefully considered what will happen if the case does not settle, they might quickly reject a settlement offer when it might be in their best interest. Make sure your client understands that their best alternative to a negotiated agreement becomes their measuring stick for evaluating any settlement offer. Without this framework, you'll find yourself in the uncomfortable position of trying to counsel a client who's hearing these realities for the first time during high-stakes negotiation. Decision-making authority is very important. Ensure that all decision makers are present or at a minimum available for the mediation. If you have a case that involves an insurance policy that could contribute to a potential settlement, it's important that a representative of that insurance company with settlement authority is present or available at the mediation. If this is a business dispute, make sure that there is a corporate representative present or available who has settlement authority. If it's an individual case, that's easy. Make sure your client is present and prepared. If it's a class action case, make sure that you have a class representative, either present or available, who understands the case and can discuss settlement with you. It's important before the mediation to confirm authority to approve terms and understand the approval process. The last thing you want to do at your mediation is spend all day negotiating a settlement, get close to a settlement agreement, and then realize that the right people are not in the room. That is one of the worst possible outcomes. Preparation prevents frustration. Have multiple settlement options ready and ensure decision makers have full authority to negotiate. All right, that concludes our discussion about range of options. I'm going to check, and it looks like we have a question. Okay, the next question is about joint sessions. So I'm going to actually discuss joint sessions a little bit more coming up. So that was a good preview. So thank you for that question. Okay, our next, we now have our second C, which is calm. Stay focused and curious. If I had to pick the most important of the 6 topics that we are discussing today, staying calm would be the one. I have seen so many mediations derail when one party gets mad and leaves. If you leave mediation early, there is a 100% chance that the case will not settle. If you stay, there's a greater than 0% chance that the case will settle, and an even greater chance that you will actually learn something valuable. I tell clients, don't give me paid time off. You most likely have paid your mediator for a full day. Take advantage of that full day. You never know what might happen. But if you leave, you know what will happen. The case will not resolve. Now, mediation can be emotionally charged. That is a fact, especially when disputes involve personal animosities or very high stakes. A natural response can sometimes be anger, frustration, and defensiveness. But these emotions are the enemy of resolution. Prepare yourself and your client mentally for this challenge. Discuss ahead of time how you will handle provocative statements or unreasonable positions. Remember that the other side may be testing your resolve or trying to gauge your true bottom line through their behavior. Now, if you only remember one thing from this presentation, I hope you'll remember this. When tensions flare, don't get furious, get curious. Ask the mediator these strategic W questions. Why is the person acting this way? What are they really trying to say? What is underneath their position or emotion? Who is driving this process? By asking these questions, you are going to learn information that can help move the process along. Let's break it down. Why is this person acting this way? Consider a situation where the other party keeps making unreasonable demands and seems unwilling to compromise, right? We've all been there. Rather than labeling them as stubborn or getting frustrated, exploring why might uncover that they're facing pressure from stakeholders that you can't see, operating under different assumptions about market conditions, or trying to save face after a previous failed negotiation. This insight can help you craft proposals that address these hidden constraints while still meeting your needs. So by asking why this person is acting that way, you may uncover information that will help you understand their position and help you create a path forward. The second question, what are they really trying to say? Let's consider an example. When a party says, I want X dollars or nothing, they might really be saying, I need to feel that the harm I suffered is being taken seriously. Understanding this allows you to explore non-monetary ways to acknowledge the impact, perhaps through an apology, a policy change, or a public recognition that could satisfy their core need for validation while reducing the financial burden. Or my favorite, when a party says, this is my last, best, and final offer. I've heard this so many times. Ask the mediator, what are they really trying to say? They might be trying to say they're exhausted, they're tired, they're frustrated. Ask the mediator, do you really think this is their last, best, and final offer? It's a very overused phrase. Sometimes it's true, but ask, is that what they're really trying to say, or is there something else going on? The next question, what is underneath their position or emotion? This is really important. Let's consider a few examples. An employee demands reinstatement to their former position, which the employer flatly refuses. Underneath this position, the employee might need financial security, professional reputation repair, or validation that they weren't terminated unfairly. Understanding what's underneath their position opens alternatives like enhanced severance with positive references, consulting arrangements that preserve income flow without creating an employer relationship, or a neutral statement about the departure that protects their reputation without admitting wrongdoing. Let's consider this in the context of an intellectual property dispute. A company demands cessation of all use of allegedly infringing technology, while the accused party claims the right to continue. The underlying interests might be market protection and licensing revenue for the first party, and avoiding costly redesign while maintaining a competitive position for the second. This could lead to licensing agreements, field of use restrictions, or collaborative development arrangements that benefit both parties. Let's talk about this in a personal injury case as an example. A plaintiff demands a specific monetary amount while the defendant offers much less. Underneath, the plaintiff might need ongoing medical care, lost income replacement. They might need assurance that their family is protected, while the defendant might need to manage insurance implications and policy limits. And the defendant might want to avoid a precedent-setting settlement. So in this case, solutions could include a structured settlement, medical payment arrangements, or agreements that meet the plaintiff's needs while fitting the defendant's risk management parameters. So the key insight in asking what is underneath their position or emotion is that positions are often just the first solution someone thinks of to meet their underlying needs. But when you understand what they're really trying to achieve or protect, then you can often find multiple pathways to satisfy those interests while also meeting your own needs. This transforms zero-sum thinking into collaborative problem solving. I see that we have a question. I'm going to address this last question, and then I will answer the question that's in the chat. So the last W question that you want to ask your mediator, and obviously feel free to add additional. These are just some ideas that I have for you. And this is also a critical one, is who is driving the process? Asking the mediator to tell you who is driving the process reveals the actual decision-making dynamics, which is crucial for effective mediation strategy and realistic expectations. And this comes up a lot in mediations. So let's use a few examples. In a business dispute, a corporate representative may participate actively, but lack settlement authority, where the real decisions are being made by an absent CEO, a board, or an insurance carrier. Recognizing this, recognizing the, excuse me, recognizing who the real decision maker is prevents wasting time negotiating with someone who can't actually agree to terms. It might require bringing decision makers into the process or structuring agreements that account for approval requirements. Now, we always want to avoid this from happening, and we talked about that earlier, about making sure that we have the right people in the room before the mediation begins, that we have the people who have decision-making authority. But if you get to a point where that didn't happen, it's important to recognize it and figure out how to move forward. Note that there also can be institutional constraints. For example, a school district representative might want to settle, but their position is being driven by the school board or an insurance company with different risk tolerance and priorities. This can also sometimes happen in government cases where a representative of the government doesn't have final settlement authority and has to get it from superiors. So it's really important to understand who's really calling the shots. This is going to help frame proposals in terms that will appeal to those ultimate decision makers and their specific concerns about precedent, budget, insurance, or policy implications. We also know that sometimes the attorney is driving the process more than the client, perhaps due to fee arrangements, personal relationships, or professional reputational concerns. Conversely, sometimes clients may be overruling sound legal advice due to emotional factors. Asking the mediator who's driving the process can help the mediator also frame their discussions with the other side to understand who they need to talk to get to a point where there can be a real discussion about settlement. So when you understand who's really driving the process, you can direct your most persuasive arguments to the actual decision makers. You can address the real concerns and motivations behind stated positions. You can anticipate which proposals are likely to gain traction. You can identify, if necessary, when additional stakeholders need to be included in the process. And you can adjust your expectations based on the approval process if there's a timeline that needs to occur. Okay, let's now go to, I think we have a question here. Oh, this is the same question that we're going to address. All right. Okay, continuing on our discussion about staying focused and curious, let's talk about a comparison between anger and curiosity. When anger takes over, it shuts down communication. It derails the productive discussions. It creates an adversarial environment, and sometimes people leave early. When curiosity leads, it opens communication. It uncovers hidden interests. It reveals opportunities for compromise. and maintains a collaborative environment. In the context of mediation, anger shuts down communication, but curiosity opens it up. When attorneys get curious, they're more likely to uncover hidden interests, misunderstandings, and opportunities for compromise. So maintain a solution-focused mindset, not an emotional one. The key takeaway from our discussion about staying calm and focused is when tensions flare, don't get furious, get curious. Ask W questions to transform conflict into opportunity. Okay, now we're going to talk a little bit more about joint sessions. I know we've had a few a few questions about joint sessions. And frankly, this is one of my favorite parts of the presentation because I truly believe that joint sessions are underutilized in mediations. So now we are at L, learning through joint sessions. Consider asking the mediator to start the mediation with a joint session. While joint sessions have become less common and some attorneys are adamantly opposed to joint sessions, in my experience, joint sessions provide tremendously valuable learning opportunities. Think of it as free discovery. You get to see and hear from opposing counsel outside the courtroom, outside of the meet and confer process. You will hear how they view the case. You will hear what evidence they think is important. Joint sessions offer insights you simply cannot get from depositions or court filings or court appearances because you're observing the attorney in their presentation, almost akin to what an opening statement might look like at trial. You'll see how opposing counsel handles their statement, whether they're truly confident in their position, and how they prioritize their arguments. You learn just as much from what they say as what they don't say. This intelligence becomes invaluable whether you settle that day or proceed to trial months later. Even in cases where joint sessions seem risky, and I'll talk a little bit at the end I'll provide two examples of where a joint session went very well and one where it did not go well. But even in cases where joint sessions seem risky, discuss the possibility with your mediator. That can reveal a creative way to structure them safely and will help you decide whether or not it's appropriate to have a joint session in your case. Okay, what to observe and evaluate during joint sessions. Watch opposing counsel's effectiveness and persuasiveness. How compelling are their arguments? This is critical. Will they connect with a jury? Do they know the case well? Are they confident or nervous? Do they come across as trustworthy or arrogant? You may also hear from the client. What an incredible opportunity, because you may never have met the client before, or your interactions may have been limited to a deposition. So hearing from the client during a joint session can provide a lot of very useful information. Are they likable and sympathetic? What is their emotional state? Do they appear credible? These insights would be impossible to gain without a joint session. Pay attention to body language and nonverbal cues that reveal true confidence levels or underlying concerns. Notice which points they emphasize and which they gloss over. This tells you what they view as their strongest and weakest arguments. Watch how they interact with their own client during the session, as this can reveal the dynamics of their attorney-client relationship and who's driving the case strategy, right? We just talked about that. So who's the decision maker? Watching the interaction during a joint session can help you identify that information. And all of the information that you learn during joint session can help you calibrate your negotiation approach and anticipate how the case might play out at trial if it doesn't settle. Let's talk about the strategic benefits of a joint session. So joint sessions offer a preview of what opening statements might look like at trial. What themes will they emphasize? What's their strongest evidence? How might a jury view their case? What are they not addressing? Pay close attention to these dynamics and take detailed notes. Use these observations to refine your negotiation strategy and develop more informed settlement offers. Okay, so a couple examples. Joint sessions are not appropriate for every case, but I think the problem with most mediations today is there is just an assumption going into the mediation that there will be no joint session, that you'll automatically start with separate caucuses. So let me provide you with two examples. In one case, I mediated a sexual harassment case where a student sued a for-profit college for conduct by one of the professors at that college. Now, in a case like that, I might not recommend a joint session because of the high tension and emotional involvement of the case. However, when I talked to the parties in a pre-session conference, they both wanted to have a joint session. And in particular, the plaintiff strongly advocated for having a joint session. And I quickly realized why. During that joint session, the plaintiff was able to speak directly to the professor. She was able to speak directly to the owners of the college and tell them in her own words what had happened to her from her perspective. She was able to tell the owners of the college what the professor had done and what words he had used. And I could tell just watching the body language of the defendants that they listened and they heard what she was saying. It was quite powerful. Now, after the joint session, we proceeded to separate caucuses, and the case actually settled pretty quickly. I think there were 3 offers and counteroffers. And I was actually quite surprised at the number that the case settled for. I thought it was lower than what the plaintiff likely could have gotten. But the reason was her interest wasn't just dollars. Her interest was telling her story and being heard. And that was frankly more important to her. So she got an amount of money that was acceptable to her, but she got what she needed most, and that was the opportunity to tell her story and be heard. And that's an example of a case where I don't think it would have gone that well if there hadn't been a joint session. I don't think it would have settled for the amount that it settled for. It may not have settled at all. And I view that settlement as a win-win because the defendant understood that they needed to settle the case and settled, I believe, for less than they had budgeted. And the plaintiff got an amount of money that was acceptable to her and got to tell her story. So whenever people, I hear this quite often, people say, you know, a mediation is successful when both parties leave unhappy. I could not disagree with that more. I've had many cases where both parties left feeling like it was a fair settlement, and that is one example. So that's an example of where a joint session went quite well. Now, in fairness, I need to provide an example of a joint session that did not go well. Now, this case was an employment class action case, which was a wage and hour case, so it didn't seem like there would be high emotions or any kind of red flags that would caution against a joint session. So I recommended that we would start with a joint session, and the parties agreed. And I talked about my priorities for joint sessions when I give the plaintiff the first opportunity to give an opening statement. I typically don't provide time limits, and I suggest, sticking to the facts and the law, and that the other side needs to not, be quiet during the other side's presentation and save any questions for after the presentation has concluded. So the plaintiff started making his opening statement, And instead of focusing on the facts and the law and the case from his perspective, he took the opportunity to disparage the defendant in ways that were very frustrating to the other side. And unfortunately, the in-house counsel for the defendant started yelling at the plaintiff attorney, which then caused the plaintiff attorney to yell back, and a very yelling ensued. And we were on Zoom, so I was like, time out, time out. Let's, everybody calm down. Well, they didn't calm down. Luckily, I had the opportunity to mute them. So I put them on mute and uh, reshared my rules for joint sessions about being, letting the other side speak and being calm. And unfortunately, when we broke into separate caucuses after the joint session, the in-house counsel was so mad and frustrated that he was not able to engage in any serious settlement discussions. He didn't get curious, he just got furious and did not ask W questions. And unfortunately, the damage was done. So definitely approach joint sessions with a degree of caution. Identify any potential red flags that you see. If there's a pre-existing relationship between the attorneys, that could be a problem. If it's a highly emotional case, if there are, family dynamics, address those issues with your mediator. But my point, I think my key takeaway is don't assume that you shouldn't have a joint session. For all of the reasons that we've discussed, joint sessions can be incredibly valuable. They are essentially free discovery. If you have them, use them to gather intelligence about opposing counsel, their client, and then preview trial dynamics. And I think you're going to find that there are more upsides to joint sessions than downsides, but as we've discussed, approach them with some caution in certain cases. Okay, that is our discussion about learning through joint sessions. And now we're going to move on to evaluating settlement offers. This is the E, the final letter that we are going to discuss. Okay. It is critical to evaluate settlement offers carefully. So now we've had the joint session and the parties are now proceeding to separate caucuses with the mediator. And the mediator at this point is going to be speaking with the parties separately, and we'll be shuttling back and forth with information and offers. Now, this is your time to be candid with the mediator. During joint session, you were advocating for your client, you were putting on your best case, you were positioning yourself strongly in this negotiation process by showing your opposing counsel that you know the facts and the law, that you are a strong advocate, and that if they take this case to trial, you are going to do very well in front of the jury. Now you get to be candid. Everything that you talk about with the mediator is going to be held in confidence. You've signed a confidentiality agreement prior to your mediation, so the mediator will not be sharing any information with the judge. And make sure that if you tell the mediator something that you don't want the other side to know, be sure that you're clear about that. But this is the time to share your concerns about the case. Every case has weakness. We all know that. No case is perfect. Share those concerns. Share your priorities. And of course, I say share your settlement parameters. Not every lawyer feels comfortable doing that. But from the plaintiff's side, you need to make an opening demand. So you need to share that with your mediator. And then, of course, the defense, the same thing, a response. If you feel comfortable sharing your settlement parameters confidentially, you can do that. That can sometimes be helpful, especially when a mediator potentially is crafting a mediator proposal at the end of the session if requested by the parties. And just to emphasize again, let the mediator know what they can share and what must stay confidential. But this is your time to really help the mediator understand your client's perspective by explaining your client's motivations, the pressures, and any non-monetary issues. Share key facts or documents that support your case, and share key facts and case law that doesn't support your case. Use the mediator as your reality testing partner. Be open to hearing the risks and weaknesses in your position. Ask the mediator to pressure test your opponent's likely response. And stay flexible. Explore creative solutions. Is there injunctive relief that could be quite useful in a case like this? Even if it differs from your initial demands, be prepared to adjust in light of new information that you've learned from the other side. And manage your time wisely. Use caucus time to refine proposals, not just to wait for the other side. And keep your client engaged and informed between sessions. I know that there can often a lot of downtime during mediation sessions. So use that time to talk to your client about what did they think about the joint session? What are their settlement parameters? I'm sure you've talked about a lot of this before the session, but when you get there, continue the discussion. And when your client receives a settlement offer, evaluate it carefully. Consider if the proposed outcome is better than what the client is likely to achieve at trial by analyzing case strength, likelihood of success, and potential costs of litigation. A common mistake is focusing solely on monetary terms. This often misses underlying interests that actually drive disputes, as I explained using the example of the sexual harassment case, where one of the underlying issues was really to be heard. Many parties have non-financial needs: preserving relationships, protecting reputation, having their voice heard, ensuring future opportunity, or receiving acknowledgement. When mediations become purely transactional negotiation over dollars, they often ignore creative solutions. And those creative solutions might provide greater value, such as an ongoing business relationship or a policy change that could cost little but deliver significant benefit. Additionally, an exclusive focus just on money can escalate emotions and entrench positions, as parties may interpret financial offers as statements about the worth or validity of their claims, rather than the practical problem-solving tools. I've seen cases where a sincere apology was worth more to a plaintiff than additional settlement dollars. I've seen situations where a defendant agreed to change a business practice, which provided the vindication that a plaintiff was really seeking. The key is to listen carefully to what the parties say they want and then explore what they actually need. Again, we're going back to understanding, asking our W questions about what are they really saying? What is underneath their position? And you also need to compare a settlement to trial prospects. Conduct a realistic litigation risk assessment. What are the strengths of your case and the likelihood of success? This is hard to do, but think of it this way. Because I know, plaintiffs don't always have a realistic version of their case, and defendants sometimes don't either. So ask yourself this question. If the case goes to trial 10 times, how many times will your client win? This isn't about being optimistic or pessimistic. It's about being brutally honest with yourself and your client. And use your mediator as your partner in this process. If you have an evaluative mediator, or even if you don't, ask the mediator, can they give their neutral assessment of your case? If there are particular important issues that need to be resolved, ask them what they think about it. It might be helpful. Think about what hurdles you have to surpass. Depending on where you are in your litigation, there might be motion to dismiss coming up, class certification, summary judgment. Each of these procedural barriers represents not just a legal challenge, but also months or years of additional expenses and uncertainty. Remember, when you settle your case during mediation, you have 100% control over what the agreement is. When you go to trial, you have very little control. It's in the hands of the judge and the jury. So consider the uncertainty that you will be facing if the case does not settle. Consider the potential costs of continued litigation. We're talking about attorney's fees, expert costs, time delays, appeals, business disruption. These costs can quickly spiral beyond their initial estimates, especially in complex cases where discovery disputes and motion practice consume significant resources. For plaintiffs, they often think justice delayed is justice denied. A settlement today may be worth more than a larger verdict years from now. A settlement has finality. Even a trial verdict is subject to appeal and retrial. For defendants, ongoing cases distract from business operations, right? The employees have to appear for a deposition. They may have to testify at trial. Ongoing cases create uncertainty that affects strategic planning and stakeholder confidence. Assess the quality of your evidence and key witnesses. What evidence will hold up at trial? Is that evidence admissible at trial? Are witnesses credible and available? Are they within the court's subpoena power? Is your evidence compelling and understandable to the average juror? This is so important to think about in complex cases where damages analysis often turns on expert opinions. You need to think about the quality of your expert testifying at trial and whether the average juror, not you who knows your case back and forth, up and down, whether the average juror is able to understand the expert testimony and the damages theory in your case. The documentary evidence that seems ironclad to you might appear confusing or irrelevant to jurors who lack your legal training and your case knowledge. Remember, you've been working on this case perhaps for years. Jurors are hearing all of this information for the first time. Consider procedural factors, judges' tendencies, venue advantages, jury pool characteristics. Maybe you've done a focus group or a mock trial. That's going to help you inform and it will help you evaluate settlement offers carefully. And remember, when you're hearing settlement offers, we need to remember to stay calm. As we discussed in the prior slide, stay calm when you're evaluating settlement proposals. You may be furious with the offer. It is either way too high or way too low and you're offended. Remember to get curious, not furious. Use your W questions. And sometimes the best option simply is to take a break. I do this quite often when I can see people getting frustrated or tired. I say, if you can, go outside and take a walk. Sometimes have a snack. If you have a pet nearby, go and spend some time with your pet. This can offer a reset when tempers flare. Let's talk about broader client goals. Consider multiple objectives beyond financial recovery. How important is confidentiality? What's the value of speed and closure versus vindication? Are there emotional considerations like an apology or acknowledgement? Are there precedent concerns about future cases? Take the time to understand your client as a whole person or organization, not just as a legal position, because the best settlements address human needs, not just legal claims. And leverage the mediator's insight. Ask the mediator's neutral perspective on offers and their assessment of trial prospects. This may provide insight into how the offer compares to similar cases or suggest creative options for bridging gaps. The mediator can sometimes craft solutions that neither party would have proposed themselves, but that both parties can accept because it comes from a neutral source. So if you get to a stalemate, consider asking for a mediator proposal. So your key takeaway from evaluating settlement offers is look beyond the dollars. Evaluate offers against your client's broader goal and realistic trials prospects, not just the monetary amount. All right, our key takeaways. Choose your mediator wisely, considering neutrality, subject matter expertise, experience in complex cases, and style match. Identify your case's strengths and weaknesses honestly to negotiate strategically. Develop a range of settlement options, including creative non-monetary terms. Stay calm and curious. When tensions flare, ask W questions to understand underlying interests. Learn through joint sessions when appropriate to gather intelligence and preview trial dynamics. Evaluate settlement offers carefully. comparing them to realistic trial prospects and your client's broader goals. Mediation gives you the opportunity to shape the outcome rather than leaving it in the hands of a judge or a jury. My information is attached on this slide. I hope you enjoyed hearing from me, and feel free to reach out if I can be of assistance in any of your cases. And I want to thank you for your intention and engagement, and a big thank you to the Beverly Hills Bar Association for this opportunity to connect with all of you. I appreciate the opportunity to share these insights with you and hope the circle method will help you approach your next mediation more strategically. I invite you to connect with me when you need a mediator, and I'm happy to discuss any specific challenges you may be facing. And now I'm happy to take questions, and I think I see a few. Oh, thank you. Thank you, Lan. I appreciate that. Oh, can I review the method to ensure neutrality? Absolutely. Let me try to go back to choosing our mediator wisely. So these are the 4 factors that we discussed with neutrality, making sure that the mediator doesn't have any stake in the outcome, that they have no predetermined opinions about the case, that they have no favoritism toward any party, and that you carefully vet them with targeted questions. So my advice is, when you're considering a mediator that you haven't used before, set up a meeting with them. I regularly have meetings with potential new clients, and I'm happy to answer any questions. And often it's the mediator's reaction that's just as important as their answer. If they get defensive about a question, then that's potentially something for you to think about. But it's important to ensure that your mediator is neutral in this process. It's one of the key factors for you to consider. Okay, I don't see any more questions, and it looks like our time is up. So I want to thank you all so much. I really appreciate your time today. It was an absolute pleasure, and I hope that you learned some helpful tips for unlocking success in your next complex case mediation using the circle method. Thank you very much. Have a great rest of your day.